Welcome back, future criminologists. In today's video, I will be discussing Introduction to Aggravating Circumstances. What are aggravating circumstances? Aggravating circumstances are those which, if attendant in the commission of the crime, serve to increase the penalty without, however, exceeding the maximum penalty provided by law for the offense. The basis for these aggravating circumstances is the greater perversity of the offender, manifested in the commission of the felony as shown by 1. The motivating power itself, 2. The place of commission, 3. The means and ways employed, 4. The time, 5. The personal circumstances of the offender or the offended party. The rule: in order for the aggravating circumstance to be appreciated, the aggravating or qualifying circumstance must be expressly and specifically alleged in the complaint or information. Otherwise, they cannot be considered by the trial court in its judgment, even if they are subsequently proved during trial. There are 5 kinds of aggravating circumstances. 1. Generic aggravating circumstances. 2. Specific aggravating circumstances. 3. Qualifying aggravating circumstances. 4. Inherent aggravating circumstances. And 5. Special aggravating circumstances. Generic aggravating circumstances are those that can generally apply to all crimes. For example, the aggravating circumstances of dwelling, nighttime, and recidivism. What is the effect of generic aggravating circumstance? A generic aggravating circumstance can be offset by a mitigating circumstance. If not offset by any mitigating circumstance, is to increase the penalty which should be imposed upon the accused to the maximum period, but without exceeding the limit prescribed by law. Specific aggravating circumstances are those that apply only to particular crime. For example, ignominy in crimes against chastity, cruelty and treachery in crimes against persons, and abuse of authority or confidential relations by guardians or curators in seduction, rape, acts of lasciviousness, white slavery, and corruption of minors. Qualifying aggravating circumstances are those that change the nature of the crime. For example, treachery or alevosía or evident premeditation qualifies the killing of a person to murder. What is the effect of qualifying aggravating circumstances? The effect of qualifying aggravating circumstance is not only to give its proper and exclusive name, but also to place the author thereof in such situation as to deserve no other penalty than that especially prescribed by law for said crime. Further, qualifying aggravating circumstances cannot be offset by a mitigating circumstance. When there is more than one qualifying aggravating circumstance present, one of them will be appreciated as qualifying aggravating, while the others will be considered as generic aggravating. Inherent aggravating circumstances are those that necessarily accompany the commission of the crime. For example, evident premeditation is inherent in robbery, theft, estafa, adultery, and concubinage. Special aggravating circumstances are those which arise under special conditions to increase the penalty of the offense and cannot be offset by mitigating circumstances, such as quasi-recidivism, complex crimes, error in personae, and taking advantage of public position and membership in an organized or syndicated crime group. The following are aggravating circumstances which shall not be taken into account for purposes of increasing the penalty. 1. Circumstances in which in themselves constitute a crime especially punishable by law, or 2. Circumstances which are included by the law in defining a crime and prescribing the penalty therefor. The following are aggravating circumstances which shall only serve to aggravate the liability of the principals, accomplices, and accessories as to whom such circumstances are attendant. 1. When it arises from the moral attributes of the offender. 2. When it arises from his private relations with the offended party. 3. When it arises from any personal cause. Under the revised Penal Code, the following are the aggravating circumstances, and I will discuss them or each of them in a separate video. 1. Taking advantage of public office. 2. In contempt of or with insult to public authorities. 3. With insult or lack of regard due to offended party by reason of rank, age, or sex, or committed in dwelling. 4. Abuse of confidence and abuse ungratefulness. 5. Crime in palace or in presence of the chief executive or place of religious worship. 6. Night time, an inhabited place with a ban. 7. On occasion of a calamity. 8. Aid of armed men or means to ensure impunity. 9. Recidivism. 10. Reiteration or habituality. 11. Price, reward, or promise. 12. Inundation, fire, poison. 13. Evident premeditation. 14. Craft, fraud, or disguise. 15. Superior strength or means to weaken defense. 16. Treachery. 17. Ignominy. 18. Unlawful entry. 19. Breaking wall, floor, or roof. 20. With aid of persons under 15 and by motor vehicle. 21. Cruelty. Comment down below for any suggestions or questions. For our next video, I will be discussing taking advantage of public office as one of the aggravating circumstances enumerated in the revised Penal Code.